Somebody's breathing. Is that Tom? How are you, Mr. Trask?
I'm doing great, thank you. How are you doing, Bruce?
The beard's looking good, sir.
Well, it's getting whiter.
It happens when we get old.
Yeah.
Oh, it doesn't happen to women, though. You know, they have ways to fix that, but they won't allow us to do it. In fact, I did get my hair colored last week because my wife decided she wanted to color it. I don't have any.
It's 2 o'clock. The Code Enforcement Board meeting is called to order. Bobby, will you call the roll? Can you hear me?
Yes, Julie.
Yes.
It's 2 o'clock. The Code Enforcement Board meeting is called to order. Bobby, would you please call the roll?
So we do not have Michelle Manousis on at this time. I'm trying to get them on.
Okay, thank you.
Julie, you disappeared.
I don't know how to fix that.
Go down to the
In-
bottom left corner of your
Start
screen.
video. Got it. Start video.
Yes, that's it.
Am I there now?
No.
My camera light is on.
You were there.
There's a little video camera that says share video in the bottom left-hand corner of your screen. Drag your mouse across it and click on
Where it
that.
says, I don't have anything that's share video, share screen, maybe.
No,
How's that?
that's to the right. It'll be to the far left. There you go.
You're
That's
back.
that's the same as it was before.
Okay, let's just wait until Bobby or Michelle gets on board.
Understand. Glad to see some of you folks so far. Everybody's doing well.
Yes. And yourself?
Just fine, thank you.
Meeting.
Hi. We've got part of you. Make your camera go down a little lower.
Ah,
Very good.
that's-
Thank you.
Julie, art sculpture. Hi.
Say that again, please.
Is that an art sculpture behind you or a hair dryer or what?
Oh, motherfucker.
It's a piece of glass.
Okay, thank you.
A hair dryer, yeah.
Well, just surrounded with him.
I could try moving.
Oh, no. I just was curious. No, I was just curious.
I see it does look funny sticking off my head. You've got yours where it frames you beautifully.
Well, I had to work real hard to do that.
No, everybody's gone.
They're working to connect their computer to this.
Oh.
There we go. Oops. The tech folks at the city have been very busy.
And we have Michelle joining us now.
Thank you.
Can you hear us, Michelle?
Yeah, can you hear me?
Yes.
Okay, just my face isn't on there, but we're good with that.
Thank you.
Michelle, will you call call roll, please?
Yes, Chair Wade,
Here.
Vice Chair Archer is absent. Mr. Weeks,
Here.
Mr. Kramer,
Yes.
Mr. Robinson is absent today. Ms. Norfleet,
Here,
Ms. Tellier,
Here,
and Mr. Perfidio is absent as well.
How many of us does that leave?
1, 2, 3, 5. You have a quorum.
Okay, thank you. Mr. Trask, would you give the invocation and lead the pledge, please?
Yes, I'd be happy to. Our Heavenly Father, send on your blessing on this meeting of the Code Enforcement Board. Give the board members a clear sense of duty and lead them to a faithful discharge of the same. Direct them in their deliberations at this meeting so that all things may be done to the glory of thy name and the welfare of the people of Tarpon Springs. This we pray. Amen. I pledge allegiance to the
to
flag
the flag of the
United
United
States of
States of
America,
America,
to the
and
republic for which
for which
it
it stands,
one
one
nation,
nation,
under
under
God,
God,
indivisible,
indivisible,
with liberty and justice for all.
for all.
Thank you very much. I'm going to read the board proceedings out loud. Be sure everyone turn off your cell phones, even if you're home, because it does create a weird phone sound distraction. It's the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedures of this board is as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is able to ask the city witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violators' witnesses. After both rounds of testimony, both on the part of the city and the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of the meeting, discuss it and take appropriate action. Normally, we would swear in all witnesses at this time. Doing this virtually, we're going to swear them in as each case proceeds. Are there any agenda changes?
The city has no agenda changes.
Thank you. In that case, we'll start with new business, which is Henry Smith, 1629 Grandview Drive, case number 20-8000116. Officer Gaston?
You stated this is case number 20-800000116. I'm Officer Steve Gaston, City of Tarpon Springs Police Department Code Enforcement. The address within the city is 1629 Grandview Drive, although this is a vacant lot with parcel number 1727-16-31356-0030060. There's no prior cases on this property. Exhibit number 1 going before the board are all of my photographs. Exhibit number 2 are all the notices that include the notice of violation and notice of hearings. Exhibit 3, administrative documents, case summary, property appraiser, and tax collector records. And exhibit number 4 is the affidavit of posting and a copy of the sign.
Can I interrupt you for
Yes.
1 second? Can we confirm whether or not there is anyone present for this agenda item?
I was about to say, I know his attorney was wanting to join.
Do we have any raised hands?
We do have a raised hand.
Thank you. If you'd let him in, please.
Can you hear me?
We can hear you. Would you identify yourself, please?
Yes. My name is Michael Kuskudis. I'm an attorney here in Tarpon Springs. My office address is 623 East Tarpon Avenue, Tarpon Springs, Florida.
And your relationship is you're representing this property owner?
That is correct.
Do you have any legal objection to the city's evidence being received?
I haven't seen the city's evidence, but I would say for the as far as photographs, I think, well, I'm sorry, take it back. Mr. Gaston did send me a package that had the photographs on there. If that's what you're referring to, yes, I have seen it.
That is the city's evidence, yes?
Yes, that is correct. It's just the photographs. And then the only other thing are the notice of hearings and the notice of violations.
Yeah, I have no objection to having that presented in front of the board.
And Madam Chair, just so you're aware, this case that I'm doing, 116, the adjoining property, which is the next case on the agenda, 179, both
Yes.
the same property owners, and Mr. Kuskudis, I'm sure, is going to be representing both of them. They both kind of tie together, just so you're aware. So some of it's going to kind of bleed together, if you will.
Okay. I did not hear affirmatively from Mr. Kuskudis if he has any objection or not.
No, I did say I have no objection for the board having that information.
Okay, your sound is just a little weak, so I couldn't hear you. Thank you. All right, we will continue then. Thank you.
Moving forward, all of the photographs and exhibits that were mailed to the violator or emailed are exact copies of what's being presented to this board. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent return receipt as well as first-class mail. And Madam Chair, please accept all these exhibits into the record as evidence.
Thank you, Ms. Manous.
So no,
May I ask a question just for housekeeping purposes? The fact that there are 2 cases, would it be, and I guess this would go to Mr. Trask, is if we could consolidate the two violations so that we don't make the same argument on the next one.
So Madam Chair, you can go ahead and hear the same testimony, but you need 2 separate motions. It's 2 separate properties.
Well, I just need to read the other property address and number into this.
You can go ahead and finish the first case. Go ahead and finish the first case and then let Mr. Gaston present the rest. in case there is, for example, something that's happening on one parcel that's not happening on the other. But he does not need to repeat himself the second time around if in fact it's the exact same testimony, so long as you and Mr. Kaskudis agree.
Mr. Kaskudis, I agree. Do you?
Sorry. Yeah, that's fine. I have no objection to that.
Thank you. Then we can proceed.
Thank you. We have had contact with the owner, and obviously Mr. Kaskudis and I have been out to the property a couple of times. We've seen it, and we've spoke with the property owner numerous times, both in person and via email. The case originally started back March 13th of 2020. There was a large amount of fill dirt being put onto the vacant lot, and there were no permits in the system for it. There were actually 5 to 6 dump truck full loads of sand being dumped onto the property. That's when I was called out by one of the city crews about it. And then we checked, and there were no permits and there's no site plans for the property to allow for that fill or excavation under the city code. On March 18th, the notice of violation was mailed, green card was returned, signed. It was signed COVID-19. Not quite sure who that was, but June 2nd of this year, conducted a reinspection. At that point in time, a fence permit had been issued. There were no inspections yet on that fence permit. The remaining permits were returned for revisions. And at that point in time, we sent an amended notice of violation, adding the permit violation for the fence. On June 2nd, again, the amended notice of violation where we added that permit was mailed, and the green card again was returned, signed COVID-19. On June 17th of 2020, conducted another reinspection. Shannon assisted with doing the reinspection on that date. And at that point in time, she pointed out, which I later saw, that the owner had created a barrier out of tree debris, concrete blocks, hay bales, and a silt fence. She opined that he was trying to prevent some erosion onto the property through drainage and things like that into the wetland area, which is the way these two parcels are set up. And if you want, I can bring up an overhead parcel view. There's a vacant lot directly next to a house. And then the second vacant lot is more or less kind of a wetland area. And then there's another house. So when we refer to the other parcel being kind of a wetland area, that's primary distinction between the western and the eastern lot. And fundamentally for the two cases, they're basically the same in the sense it's just one of them. There was no fill dirt put on the wetland lot, which is the other case that we're doing. There was fill brought into this lot. The other lot was just simply, we had no site plan for any building or doing anything to it. It needed to just remain a vacant lot. So, and if you'd like I said, I can bring up the picture kind of just showing the aerial of where this area is, if you would like, Madam Chair. And then Mr.
That would be helpful. Also, you mentioned Shannon. Would you clarify who that is, please? I know
Shannon Brewer with the city. She's not present. So I understand that my statements are loosely hearsay, but I went out and saw these same things. Mr. Kaskudis was also out there and saw the hay bales and things like that. But that's just what she noticed on the June 17th reinspection. That was the violation of City Code 852 because of putting the tree debris was on the property and so forth. So let me bring up that image really quick so you can see. Hopefully this will work. Hang on just a second.
You're going to share your screen.
I got to drag it over there. All right. Can everybody see that?
Yes.
Okay. So this is the case we're working on right now, 116. This lot right next door is the other case that we'll be briefly speaking about. To give you an idea, this is the back of Young Subdivision. This is Lake Tarpon. This is Grandview Drive right here. This is South Highland Avenue, US 19. I'm pointing at it like you guys can see it, is over here to the west. Oops.
Understood.
That was a mistake. Hang on. Let me see if I can undo the zoom. My mouse is not cooperating, so bear with me just a sec. There's always got to be some sort of a technical difficulty. I'm just trying to get my mouse to move so you can see it. Right now, 116. This is next door There we go. Okay. So as you can see, these are the two lots. This is when we talk about the wetland lot would be the small one to the right of the green box. So, and I'll bring up some pictures now if you'd like to kind of demonstrate what the lot looks like. And let me turn them the right direction. Hang on.
I saved them the right direction, hopefully.
Okay, so that's the wetland lot. These are on another screen. I'm finding the right ones and I'll bring them right to you guys so you can see. Maybe.
There you go.
So this is the lot we're referencing right here. This is the fence we discussed. As you can see, it's not finished yet. There's some sections missing. You'll see in some further pictures. But all of this white sand was the additional fill. What happened is the dump trucks dumped it. We told them there was already a stop work order issued. As a matter of fact, this right here on this pole is the stop work order that was issued prior to this date. And then the owner, I witnessed him on site with the dump trucks from a site up the road, dumping the loads of sand on the property. Told him again to stop all work. There were still no permits or anything. And then it came back a period of time later and he had kind of graded it out and leveled the property to some extent. Again, without any permits at that point in time, I don't believe there was any engineering or anything allowing him to do the work. This is the wetland piece. I'll skip past it really quick. Okay, so if you notice here, then the silt fence was put in, but all of this grade and elevation was changed in this area right here. This is also part of that fence that's not complete that we're referring to in the permit that the fence needs to be completed and signed off on. This is the other lot, if you will, the wetland lot. And we'll get into a tiny bit more with that. So these are the June pictures. Here you can see the fill dirt that was brought into it. Right here, this was before it was graded out. So this was how much dirt was brought in. I wish I had an original picture. As a matter of fact, I could dig around. I think I have a Google Street View. There's a Google Street View that I'll get to here in a second. There's a stop work order. And bear with me while I
The
scroll.
little white tag will tell you which one is the.
Okay. Pretty far in.
It's the,
And this is the debris that we were referring to. Now, as of right now, all of that seems to be removed. The only thing that's left as far as debris goes is there's a pile of pavers on the western lot, and on the eastern lot, there's some piles of cement. So that's the debris issue that we have right now. Primarily with this case, and I know that probably Mr. Kuskudis will bring this up. They had some engineering work done. We have not yet obtained any site permits. And so therefore, before you can bring in, especially a large amount of fill, which is substantial, like I said, it was at least 5 dump truck loads, that you have to have a site plan in place and building permits issued. And none of that was done for this property. I'm gonna, like I said, I'll see if I can find the Google Street Views and you can see the change. But it's fairly significant unless Mr. Kuskudis really wants to see the before and the after. I don't think he's got any argument to it, but if he does, I'll be more than happy to dig up the Google Street View picture of the before.
I do have a question and I could ask.
Just,
it.
we can get to that in just a second. We're going to follow the procedures. Thank you.
So finishing up on my part, on June 19th, and I'll stop screen sharing here for you guys. All right, am I back? I'm back. All right. So June 19th, the amended NOV where we added 852 and the notice of hearing was mailed. The green card was signed by Tracy Kelly. June 26th, posted the property and the affidavit of posting was signed. On July 9th, conducted another reinspection. Primarily, it was kind of what we call a paper inspection. We were just checking to see if there was any permits or what was going on within the city system. And per Michelle at the building department, all the permits were open. The fences were approved, but there was no inspections yet on them. And the site fill drainage permits have not been approved yet because they require a site plan first. And then once you determine what you're doing with the site, either a building permit or something along those lines. So none of that was approved yet. They were in the works, so to speak. On July 24th, posted the property, another affidavit of posting signed because we had deferred the case from the July Code Board. And then August 12th, conducted a final inspection. There were still no permits nor site plans that have yet been approved. So the violations before the board on this property right now are 6-1, where we adopt the 2017 Florida Building Code and the 2018 International Property Maintenance Code. Florida Building Code 105.1, which are permits are required. And then 210.00 of the city code, which requires a site plan before any fill, construction, things like that. 64.00 falls underneath of that. And basically it was putting the fill on the property without a site plan or a building permit. And then 105.1 again, but that specifically addresses the fence permit, which has not been signed off on or finalized. So that fence needs to be completed and a final inspection needs to be done on it to comply that ordinance violation. And then 8-52 was the debris and things like that on the property. Now, the photographs that I went out and took today, is a side note, the property's grossly overgrown now. So it's going to need to be maintained. And that falls in line with 852, although the initial inspection and the initial case didn't have that. So it's kind of like a little bit more of a note for Mr. Kuskudis to let his client know he's got to take care of that lot. But it falls under 852. So for this case, 116, that's primarily the city's case. And at this point, I have nothing further.
They didn't get to review those.
Does the board have any questions of the city staff?
I do. Officer Gasson,
Yes, sir.
did I understand that this started in June?
No, this started, it had started once before, and then we gained compliance for another minor issue a while back. But then in March, the stop work order was issued by the city for whatever reason. They issued the stop work order. And then they said they got a complaint about dump trucks dumping on the property in March. And then that's when I went out and saw the dump trucks there. So that's when this case that we're dealing with right now started.
Okay, thank you.
Anybody else? Now, Mr. Kuskudis, if
Yes,
you have any questions for the city staff, you'll get to do your case, but this is just direct questions.
Okay, yes, Officer Gaston.
Yeah.
When we met on the property, it wasn't just you, it was also with the engineer. That
Correct.
correct? And we discussed about what needed to be done with the property and the fact that there was a site plan application with the city.
Correct.
Correct. And as a result of that application, we found out that it was rejected with comments, obviously.
Right.
Okay, so currently there's pending and just for the board's knowledge, my client is in Ohio. He is COVID quarantined, so he's not down here in Florida. But it was also my understanding. Well, let me ask you this: the property that's directly west of these lots has about a 10-foot higher grade, 8 to 10 foot higher grade than my client's lots, correct?
It's higher. I don't know an exact height, but yeah, I'll agree that it is higher than your client's. Yes.
So we don't know what the lot conditions were because of the every time it rains, his lot would become eroded. But we don't know what the levels of that lot were at the time.
Well, like I said, we have, that's what the engineers were doing, and that's why all of the plans and everything had to go through the city prior to anything being built. But there's no argument that the property to the west was higher. But he arbitrarily decided to bring in his own fill dirt and change the grade of it without any of the approval from the city. That's kind of the reason why we're at where we're at.
Well, I mean, can you tell us what the grade was before the erosion?
I don't have any of that because there wasn't anything specific about erosion. All it simply was there was a stop work order and then work was being done and we found there was no site plans or building permits. So I don't necessarily have a dog in the race as far as what grades and things like that. I just know there was work being done without a permit.
Yeah,
And that's kind of, yeah.
Yeah, I just try to have the board understand that, where, my client's got a piece of property that every time it rains, it erodes. And, did I lose everybody?
Where everyone's gone.
What happened?
You're still
Everyone's
screen
gone.
sharing?
Oh, sorry. Thought I shut it off. There we go.
I just wanted the board to understand that the way my client's lots are situated, every time it rains, it erodes. And so, and I try to get with Mr. Gaston early on as he would acknowledge to try to resolve these issues. And correct me if I'm wrong, Mr. Gaston, my client has moved forward to try to get everything as far as the permitting through the city at this point.
Right. And from what I get right now that's occurring with the city is he, I guess, hasn't decided whether or not he's putting a house on it or not. So it's extremely hard for them to approve some sort of a site plan. And the other problem is his eastern lot's for sale. So you can't get a building permit for residential structure when the property is for sale. And then there's another caveat that he's been informed of from what the building department says. He's trying to do a single family home on 2 different parcels. And if you do that, you have to be a contractor. You can only apply for that single family home on 1 parcel as a private person. So those are some things that are causing him some major issues. The erosion, I don't think anybody wants to necessarily argue with that, but there's another caveat to that. He got a grubbing permit and went and cleared the land and the majority of the trees off of it, which did drastically change how it drained. So you're absolutely correct. Water's going to go a certain way and it is downhill of everything above it. But there were some things taken by Mr. Smith that were outside the scope. Yes, he was approved for the grubbing permit and to have the trees removed. And I think Shannon dealt with that issue in a different case. But it was done. And then that consequently caused some major downland problems because there was nothing there to stop the water. So then from what Mr. Smith explained, and unfortunately he's not here, that's why he was wanting to bring the dirt in to kind of grade it off, but he had no plans and no site permits. So that's the conundrum we're in right now.
Yeah,
We're good.
go ahead.
Mr. Kudos, this is the part where you ask questions. You'll be able to present your case, but the direct questions are appropriate at this time.
I am asking questions. Okay, let me ask another, Officer Gasson. Correct me if I'm wrong. Okay, I received an email from the engineer who said that as far as the site plan is concerned, they won't grant a site plan permit without a construction permit.
If that's what the building department said, then that's correct. Yes.
Okay, so to the extent that he has filed for his site plan permit and was denied because they're saying he didn't add construction plans, that's kind of pretty consistent with our, the discussion we had about giving us time to go ahead and get those things in order. Is that correct?
Correct. And as we've discussed, he's asked for time and obviously that usually comes up towards the end. And we were both in agreement about giving him, this isn't one of those things that's going to occur overnight. We know that there's some intricacies that have to deal with once we get engineers involved, architects, attorneys, all due respect. The folks at planning and zoning and things like that. We're well aware there's time, and I'll be painfully honest. I depend on those folks to kind of tell me I'm the conduit to bring the case before this board and present it as kind of simplified as possible. Because of the simple fact that work was being done outside the stop work order and the work shouldn't have been done because there were no permits. And so, yes, we have to deal with those permits and figure out a solution for that.
So So I guess the question is, part of the compliance requirements actually have to go through the city building department.
And planning.
And planning and zoning, yes. And
Planning and
we were discussing this case today, and we'll be putting a plan together for your client so that we can get him in compliance, because that's what we want. So we will have a plan, not next week, but the week after.
Yeah, I just don't want the board to think that, you know, this is not, that compliance versus non-compliance is something that we're ignoring.
Right. You know, but obviously we're here.
I'm going to need to interrupt because he continues to testify without asking questions.
That is a question.
If you'd like to present your case at this time, we'd love to hear.
I asked the question, Chair. That was a question. That's a question that asked for an affirmative response or a negative response. So that was a question.
Do you have another question?
No, not at this time.
Then would you like to present your case?
I think I did present my case through the question process.
Does the city staff have any questions for the respondent?
Hey, Mike, we had discussed this, and your client had asked for 90 days to try to work through all this stuff. Is that still the time frame we're talking about on the table?
Yes, he does have an engineer employed and a environmental engineer also employed. And I guess from the email I got today, he's going to have to submit some construction plans.
Okay, that's all the city has at this point, ma'am.
Does the board have any questions for the owner? I do. Why did you dump all this fill dirt on this property without a permit?
Okay, I didn't dump any filled dirt, but if you're asking if
Why did your client do so?
Okay. If you, I don't know if you made a site inspection of the property, but the property directly west of my client has about an 8 to 10 foot elevation over and above my client. You know, obviously he's not from this area. He did get a grub permit, which he assumed by grubbing, he'd be able to put some fill in. Obviously that wasn't the case without a permit, but every time it rains, the property erodes.
Got it. And how long has he owned this property?
I couldn't tell you. I couldn't tell you. Mr. Gasson probably has that public record.
I'm sorry, what was the question again, ma'am?
How long has he owned the property?
I think it was fairly, hang on, I actually have it pulled up. Give me just a second.
Property
Is
appraisal.
everybody okay?
What was it?
I think somebody was knocking on the door. Hang on just a second. I'm pulling up the property appraiser. I'll tell you here in just a second when the property was transferred. It looks like the last transaction according to the Pinellas County Property Appraiser, which was a deed, it was the beginning of the year, about February 19th of this year. So he's only owned it this year.
Okay, thank you.
Over there. Go lie
Anybody
down.
else have any questions?
Go lie down.
Staff, would you like to summarize further?
Just briefly, like we discussed, you know, we have these violations. We just kind of want to set a timetable to try to get them resolved, both on the city's part. I mean, I know we have some things we have to do on our end, but then once those things are accomplished on our end, we would like to see, like we discussed, like 90 days for them to be in compliance, which is submitting that site plan and just getting the property cleaned up as far as debris and things like that goes. That's all the city has.
Does the respondent have a summary for your side of the case?
Yes, my client has, while he was here, he did make a good faith effort to try to clean up the property. Obviously, there's more cleaning that has to be done. And we sort of agree that a 90-day window would grant us the opportunity to go ahead and process some of the permit requirements through the city and the objections in the applications we've already submitted with the city to address the comments that the city has on those permit applications.
Thank you very much. The public portion of the case is now closed. Would the board like to entertain a motion, please?
I move based on the testimony, evidence, and facts presented and the law that at the time of the alleged violations, section City Code 6-1 FBC 105.1, FBC 105.1, City Code 210.00, City Code 64.00, and City Code 8-52. Or suffer a fine of $100 a day for each day thereafter that the respondent remains in violation thereof. Whoops.
I'll second that.
Yeah. I'm sorry, I did the first, I apologize. Let me start again. I went from the first
Let's
motion to
withdraw.
the second motion.
We'll officially withdraw that first motion and we'll replace it. And Mr. Kramer, you'll withdraw your second and we'll go again.
Thank you. I move based on the testimony, evidence, and facts presented in the law that at the time the alleged violations, section City Code 6-1, FBC 105.1, FBC 105.1, City Code 210.00, City Code 64.00, City Code 8-52 of the city codes of the City of Tarpon Springs was in force and effect, and the respondent was in violation thereof.
Thank you. Do I hear a second?
Second.
Thank you, Mr. Kramer. If there's any discussion from the board. Ms. Manousis, would you call the roll, please?
Ms. Tellier? Ms. Norfleet? Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Chair Wade?
Yes.
I can't hear you.
And Mr. Kuskudis, if I understand correctly, you felt comfortable with a client's compliance date of 90 days.
Yes, ma'am.
Okay. Then we'll ask the city staff for an additional input with regard to a recommended timeframe in compliance.
So, thank you, guys.
Staff, like I said, 90 days is fine with us, and whatever the board feels necessary fine-wise.
And just for the sake of housekeeping, with regard to, I know it's this case, but I would guess the same arguments for the next case and ask for the same result.
All righty, let's complete this one. Could I hear a motion, please?
I move that the respondent shall have until November the 12th to bring the property into compliance with code sections City Code 6-1, FBC 105.1, FBC 105.1, City Code 210, City Code 64.00, City Code 8-52, or suffer a fine of $100 a day for each day thereafter that the respondent remain in violation thereof.
Second.
Thank you, Ms. Manousis. Unless there's discussion, hearing none, we'll take a vote, please.
Ms. Tellier?
Yes.
Ms. Norfleet? Ms. Norfleet, you're muted. You're muted. Your computer is muted.
Bottom left.
It's on the bottom left corner.
Okay, let's do this. Just thumbs up
Yes
if
or
you're in
no?
agreement. Thumbs up if you're in agreement with the motion, or thumbs down. Thumbs up. There you go.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Chair Wade?
Yes.
Thank you.
Mr. Trask, would you like to, should we combine the other one now and you can just summarize once? Help me out, please.
I'll just go ahead and summarize this, and then we'll move on to the next one. So,
Okay.
Mr. Kuskudis, the property owner has been found in violation of the cited code sections, been given a compliance date until November 12th of this year Should the property not be brought into compliance with the code sections that were cited, a $100 per day fine will be issued. An order will be entered within the next 10 days and provided to your client at the address listed at the property appraiser's records. And obviously, city staff will also provide you a courtesy copy of that order. So that's a summary of that particular case. And Madam Chair, we can move on to the next one now.
Okay, can I just respond real quick? I have no objection. The only thing, and I talked to Officer Gaston about this, if compliance versus non-compliance means that there are documents or permits or plans that are submitted to the city and the delay is not caused, and I'll work that through with Officer Gaston. I just don't want, a technical review or some type of review delay us being in compliance versus non-compliance, if that makes sense.
So Mike, it's not a time to negotiate with the code enforcement board.
I know, I will work
You
that
can
out.
work with city staff on that after the fact if you have other questions or concerns. And obviously, if the property is not brought into compliance within a certain period of time, then you can always come back and talk to the board about that on petition for rehearing or reconsideration.
Thank you.
Okay, Mike, thanks.
I like the beer tongue.
Like the beard tongue.
Does that count for number 1 and 2, or do we need to officially put that number in as well?
You need to hear the case, the second case. It could be an abbreviated version, but you need to go ahead.
Okay. Is Mr. Kuskuda still there?
Yes, he
I
is.
am. Would
All
it
right.
be easier if I stipulate, Mr. Trask?
It all depends on how the city wants to move forward with the case, Mike.
Well, if I think it's the same result, I'll let Mr. Gaston do it.
Okay.
All right, item number 2.
Yeah.
Item number 2, 1621 Grandview Drive, Henry Smith. Is anyone present for that agenda item?
Michael Kuskudis on behalf of Mr. Smith.
Thank you.
You ready?
And we already have established your relationship to the property. Did we swear him in before?
You don't
Yeah.
need to
Attorney.
swear in Mr. Kuskudis.
He's
Okay,
an attorney.
still has to tell the truth.
That's right. He's an officer of the court. He will be doing that.
Thank you.
Okay.
Do you have any legal objection to why the city's evidence should not be received?
No.
Thank you. Officer Gasson, would you like to please?
Yeah, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case before the board is 20-800000179. It's listed within the city as 1621 Grandview Drive, although it's a vacant lot owned by Henry Smith. Parcel number 172716 31356 003 0050. If the city possibly can, this is a duplicate of the previous case 116. There is no new or differing information other than the parcel number. All of the other facts of the case are the same. And if that satisfies the board and council, then the city would rest at this point.
Thank you. Mr. Kuskudis, is that satisfying?
Yes, it does. Thank you.
Thank you. Can we just skip down and summarize?
Yes.
Thank you. City staff, would you like to summarize, please?
My summary is going to be basically the same as the last case and the same 90-day consideration in working with the Violators Council.
Thank you. Do you have anything else, Mr. Kuskudis?
No, I do not.
Okay. The public portion is now closed. I'd like to entertain a motion from the board.
I'll make the motion, Julie.
Thank
I
you.
move that based on the testimony, evidence, and facts presented in the law, that at the time of the alleged violation, Section City Code 6-1, FBC 105.1, FBC 105.1, City Code 210.
Feel free to bring me a water, my water.
00, City Code 64, and City Code 8-52 of the City Code ordinances of City of Tarpon Spring were in effect. The respondent was in violation thereof.
Second.
Thank you.
We ready?
I'm going to assume there's no discussion from the board, and I'll have you call the roll, Ms. Manousis.
Ms. Tellier?
Yes.
Ms. Norfleet?
Yes.
Okay, you're on. Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Chair Wade?
Yes.
And I believe for the record, Miss Vice Chair Archer is with us now.
Yay.
Ms. Archer, can you hear us? I see her on the screen.
She's muted right now.
Okay.
There she is.
Okay.
So
Welcome. Welcome,
There
Ms.
she
Archer.
is.
she's
There
there.
she
So you,
is.
you can include her on the vote then. Ms. Archer, did you hear the whole case presented? We can't hear you. If you did,
Hear me now?
yes,
You can hear me now?
yes.
Oh, wonderful.
Did you hear the entire case?
Yes.
Okay,
Okay.
so we can go ahead and include her vote. So Michelle, did you want to include that? Are you in favor of or against the vote or this motion? Ms. Archer?
Well, I was on the phone with Mike during the motion part, so I don't,
Okay,
what was the motion?
They've
All
been found in violation, and for right, that's where we got so far.
All right, yes.
Okay.
In this city and the violator have already expressed agreement on the second portion, but I need to hear a motion from the board, please.
I move that the respondent shall have until November 12th to bring the property into compliance with city codes 6-1, FBC 105.1, city code 210.00, city code 64, and city code 8-52, or suffer a fine of $100 per day thereafter. The respondent remains in violation of thereof.
Second.
Thank you. Ms. Manousis, unless there's discussion? Hearing none, we'll have a roll call.
Ms. Tellier?
Yes.
Ms. Norfleet?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Vice Chair Archer?
Yes.
Chair Wade?
Yes.
Thank you.
Would you like to summarize again, Mr. Trask, or was that sufficient?
so Mr. Kasudas, the order is going to be similar to the one in the first case. Do you have any questions about that?
No.
Okay, thank you.
Thank you.
All right, so we can move on to the third case and let Mr. Kasudas drop off. And we need to go ahead and swear in Mr. Gasson.
Thank you.
So I'm going to go ahead and do that. Hold your right hand up. You swear the testimony you're about to give is going to be the truth, the whole truth, nothing but the truth?
I do.
Thank you. Okay.
The next item is item number 3 on our agenda. It's a repeat violator. I do not have a name for this, but it's 60 Burton Place. Case number 20-8000344. Is anyone present for that agenda item?
We do have a raised hand. I'll allow them to talk.
Thank you.
Yes, I'm here.
Could you give us your name,
Lee
please?
Silva.
What's the first name? What's the first name?
Oh, she went away.
Ms. Silva, what's your relationship to this property?
Can you hear me? Can you hear me?
Now we can. Could you confirm your relationship to this property, please? And then we'll need to swear you in if you're going to testify. Ms. Silva, are you there?
Yeah, they're talking. Somebody's talking.
Ms. Silva,
I think she's on the line with our IT people.
She
Okay.
said something, I don't like something.
There you go.
Oh, no.
Ms. Silva,
She's muted.
Can you hear me now?
Yes.
are you Ms.
Alternate
Silva?
A to unmute. Where's Alt? R.
You are now muted, so go ahead and re-unmute. Almost. Try one more time.
Okay. Can you hear me now?
Yes,
Yes,
ma'am.
ma'am.
Could you tell us your address and relationship to this property,
Oh
please?
my gosh. How about now?
Yes,
We
ma'am.
can hear you. Can you confirm your address and your relationship to
I'm
this
gonna call
property?
in.
Madam Chair, why don't we
Skip it and
just
come back?
come back to this case and hopefully she'll get a good connection and we'll be able to proceed with her attendance. So if we could go to the next case then on the
Madam
docket.
Chair, this is the only problem. This person, Sue Silva, is representing the 3 cases, this case and the next 2 cases. So however you want to do that. And then I think we're into old business by that time.
I told her how to.
I think she's trying to call in right now. So, I mean, it's up to you how you want to handle it, but the last of our new business is all with her.
Understood.
And just for when she does finally join us, Ms. Wade.
I called in. Hello.
Okay.
I'm sorry. I don't know what happened there.
Just so you know, Ms. Wade, we have emails from all 3 of the property owners on all 3 of these cases allowing her to represent them. So the city has no objection to any of that in the next 3 cases, just for your information.
What's the relationship of her to the property?
She's property manager.
Do we need to swear her in then, please?
Yes, I'll go ahead and do that. Can you please state your full name?
Susan A. Silva.
Okay, I need you to raise your right hand. I'm going to swear you under oath. You swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
And if you could wait 1 second. Ms. Silva,
Yes.
you'll need to either mute your computer or your phone because we are hearing a repeat. So when we talk and you talk, all we hear is the re-echo.
How's that?
Everything's muted.
Pick one.
How's that?
Oh,
That
much
is much
better.
Thank you, ma'am.
We got it.
Okay.
All right, we'll start again. This is agenda item 3. The number is 20-8000344 60 Burton Place. And Ms. Silva has been sworn in and she's representing the property owner. Is that Meyer Lane Investments?
Yes, actually, the same scenario would apply in this instance as your previous property
Okay.
owner, because the 3 lots are owned. 1 is Mitchell and the 2 are Meyer Lane, and it's
All right,
the same violation.
We're gonna treat them the same way. We're gonna work through number 1 and then see if we can do number 2 and 3 more quickly then, if that suits you.
Okay. Yep, perfect.
Are you ready,
Do
ma'am?
you have any legal objection, Ms. Silva, to the city presenting their evidence and having it received?
I don't have any objection to the the documentation. I just don't know if that also means the fine.
This is just a presentation of the evidence.
Okay, then no, I have no objection.
Thank you. City, would you like to present your case, please?
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. This is a repeat violator case. It's a repeat violator case for case number 18-800000344, which was a violation of City Code 8-52. Previously, that case was established. There was no fines assigned to it. The case before the board right now is case number 20-800000344. Property's addressed, although it's a vacant lot, as 60 Burton Place. Property is owned by Meyer Lane Investments LLC. The parcel number is 082716488700000020. Exhibit number 1 going before the board are all of the photographs. Exhibit number 2, all the notices, including the notice of violation and notice of hearing. Exhibit number 3, administrative documents, case summary, previous board orders, the property appraiser and tax collector records. Exhibit 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. All of the photographs and exhibits are given to the violator, exact copies of what's being presented to the board. All of my notices are mailed to the property owner record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations or notice of hearing are sent both return receipt requested as well as first-class mail. And Madam Chair, please accept all these exhibits into the record as evidence.
Thank you. Ms. Manousos has done so. Would you like to present the case, please?
All right, thank you. We have had contact with the owner via phone. Case started on July 13th of this year. Basically, the lot was overgrown and needed to be mowed, trimmed, edged, and continually maintained. On July 13th, the notice of violation as well as the repeat violator notice of hearing was mailed. Both the green cards were returned signed. Conducted a reinspection on July 21st, and it was in compliance on that date. On July 24th, I posted the property and an affidavit of posting was signed. The property was in violation for a period of 5 days from the date of the initial inspection on July 13th of 2020 until it was complied on July 18th. As I stated, I conducted the reinspection on the 21st, but as you guys historically know, I was informed of the date that it was maintained, and we will use that date as the date of compliance. So it was out of compliance for a period of 5 days. And at this point, that's all the city has on this case.
Does the board have any questions for city staff? Ms. Silva, do you have any questions for the city staff? This will be just questions.
I don't.
This
Yeah,
will be
my
just
question would be, yes. As I talked to Beth, I received the notice on the 17th when I came into the office on Friday, and we had it taken care of on the 18th. So my only question is does it count that I received the letter on the 17th? So I would be out of compliance for 1 day and not the 5 days?
No.
Okay. That would be my only question.
Staff, do you have any questions for her?
I have no questions. Thank you.
All right. Now, Ms. Silva, would you like to present your case?
Yes, I'm not real sure I don't remember when the first offense happened. But just to explain what happened recently was we have a lawn man. He monitors it for us and cuts it as needed. Obviously missed a cut. And as soon as I got the letter, the next day had him out there, which was a Saturday. And we've since then hired a new company, a local company called Green Thumb. I think they're based actually out of Tarpon. They've already cut it. I think it was this morning, and they are on a contract now to cut every 2 weeks. So this will not happen again.
Does the board have any questions for the owner? City staff questions for the owner?
We have no questions.
Would you like to summarize, Officer Gasson?
I don't have a summary other than the fact I will, and I'll stipulate it on the next case. This is going to be identical to the next case owned by the same property owner, but the city has nothing further.
Understand? I'm going to close the public portion of the case, and board, if you would like to present a motion. And since this is a repeat violator, you can do the guilt phase and the penalty phase as one motion, I think.
I move that based on the testimony, evidence, facts presented by law, that the respondent was in violation of section 8-52 of the Tarpon Springs City Code from July 13th to July the 18th. A fine of $100 a day for 5 days, or a fine of $500. In addition, I move that the city be awarded $87 for the cost it incurred in prosecuting the case.
Second.
Is there's any discussion? Do you realize that that's going to be ×3 for her?
Could be,
And the motion stands?
yes.
I just think that's a little stout because there's going to be 3 in a row. And I heard what the young lady said, and it sounds like she's got a handle on it. And we can always ask Officer Gates and his opinion of this, but I would, wow, that's just a lot of money. We're not cutting your grass, and I think.
I concur.
My guess is they learned their lesson, so I would cut this down to
I would say
$100
that they have 3 lessons to learn here. And this is the
It's up
first,
to you guys.
I'm going to withdraw my second.
okay?
The motion failed for lack of a second. Could I hear another motion, please?
Tom?
I move that based on the testimony, evidence, and facts presented by law, that the respondent was in violation of section 8-52 of the city code from July the 13th to July the 18th, and a fine of $25 a day for 5 days, and a fine of $125. In addition, I move that the city be awarded $87 for the cost it incurred in prosecuting the case.
Yeah, I'll second that one.
I need to confirm that I heard that correctly. $25 a day for 5 days.
Yes.
Thank you. Could we have unless somebody else has anything to say, we'll get a roll call.
Ms. Tellier,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes,
Mr. Weeks,
Yes.
Vice Chair Archer,
Yes.
Chair Wade.
Yes. Do you want to summarize for us, Mr. Trask, or do you want to wait and do it all at once?
I'll be happy to do it here. So Ms. Silva, this property owner, Meyer Lane Investments, has been found in violation of section 8-52 of the code as a repeat violator, been fined $25 a day for 5 days. In addition to that, the Code Enforcement Board has awarded the city $87 in prosecution costs. An order will be entered within the next 10 days and provided to the property owner listed at the address listed by the property appraiser's records. So if you have any questions about what you need to do after this hearing, please contact the Code Enforcement Department and they'll help you through that. And I understand we got 2 more cases to go. It's going to be I may address that as well when we get done with those cases.
So Mr. Trask, we need to go through all the same steps for each one of these?
Yes, I would suggest that because they are different property owners, at least in cases 4 and 5.
I understand. Thank you. We want to do it right. Our next case is case number 4. It's 1458 Meyer Lane. The owner is listed as Meyer Lane Investments, LLC, and it's case number 20-8000345. We already know that Ms. Silva is here for that agenda item. She's been sworn in. And do you have any objection, Ms. Silva, for the city to put its evidence into the case?
No, I have no.
Thank you. Mr. Gaston, Officer Gaston, would you present, please?
Yes, thank you. This is, as you stated, a repeat violator case. It's owned by the same property as the previous case, so this will be abbreviated. A repeat violator from case number 18-800000403, which was a violation of City Code 8-52, same as this case. As the previous case, it was established there was no fines. This case is 20-800000345. The address within the city system is 1458 Meyer Lane, although it is a vacant lot. Parcel number 0827164870000010. And if it's okay with Madam Chair, this is exactly the same case, same evidence, same information as the previous one with the same owner. The next case is actually a different owner, but it's an adjoining lot, just so the board knows. So if we can stipulate to that, they were in violation for the same period of time, 5 days, and the city will rest its case at that.
Thank you. Ms. Silva, any questions for him?
Yes, can you tell me when that first violation was?
It was the same date period from July 13th to July 18th.
No, when they were established.
Oh, when they were established?
The original-
Established was back in 2018. I'm sorry. I don't have the exact date though, but it was a 2018 case.
Okay. So I think they own the property since 2012. So, well, it's not a question, so I was just
Okay,
gonna state.
if you don't have any questions, you can present your side of the case.
Okay. My only rebuttal or statement would be they've owned the property since 2012, and this is not that it makes it right, but this is the second time that we were notified it needed to be cut, only because the lawn man didn't do what he was supposed to do. And I received the documentation on the 17th and immediately had it cut the following day, and have replaced the lawn people so that we don't have this happen again. But I think the record from 2012 to 2020 is says a lot for us doing what we're supposed to do.
Thank you. We appreciate that. If you notice, we did reduce the fine because we hadn't had previous things. So
I
be
did,
happy
and I
with
appreciate
that.
that. Yeah.
Does anybody else have a question for the owner? The public portion of the case is now closed, and we'll entertain a motion from the board.
I move that based on the testimony, evidence, and facts presented by law, that the respondent was in violation of section 8-52 of the Tarpon Springs City Code from the 13th of July until the 18th of July, and a fine of $25 a day for 5 days, a total fine of $125. In addition, I move that the city be awarded the $87 for the cost it incurred in prosecuting this case.
Mhm. Second.
Go ahead.
And Talia gave a second. If there's no discussion, the clerk will call the roll.
Ms. Tellier,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Vice Chair Archer,
Becky's muted.
yes,
Thank you.
and Chair Wade.
Yes, please.
Thank you.
So there's not any confusion later. I don't think there's any further discussion, and Mr. Trask will summarize.
So Ms. Silva, this is gonna be a repeat of the previous case. The same thing is gonna happen. There's gonna be an order entered. It's going to fine this property owner $25 a day for 5 days, $125 total fine plus $87 in costs have been awarded. That order is going to be issued within the next 10 days and sent to the property owner at the address listed by the property appraiser's record. If you have questions about it, again, you can contact code enforcement after the meeting.
Question about
Okay.
procedure? Question about procedure, please. Did
Yes.
we
Thank you.
vote on this?
I'm sorry?
Did we vote on this,
Yes,
on the second one? Okay,
yes, you just completed that.
yes, sir. I didn't remember us voting, that's all. Okay,
You have it down, right, Ms. Manousis?
I got
I checked it off. Okay.
okay.
Then item 4 is completed, and we'll start again on item 5. Or Ms. Silva, are you representing for David
David and
yes,
Yes, yes.
Mr. Trask?
Yes,
She has some sort of permission to present for them
well, that's what Officer Gasson testified to a little while ago, yes.
for this third party as well.
Yeah, that's
It's a
correct.
different-
We received an email from the property owner requesting that that she represents this property as well.
Got it from Mr.
Okay, thank you. I want to clarify it. Okay, this is a repeat violator, case number 20-8000346, 84 Burton Place. And the listed owner is David and Rebecca Mitchell. And we already know Ms. Silva is representing them. She's been sworn in. Ms. Silva, you have no objection to the city evidence, correct?
Correct.
Clerk's going to mark that as received into evidence, and Officer Gasson will present the case.
Thank you, Officer Steve Gasson, City of Tarpon Springs Code Enforcement. As stated, this is a repeat violator case. The previous case that established it was 18-800000402, City Code Violation 8-52. No fines, but it was established. This current case, 20-800000346. Property is addressed as 84 Burton Place. It, as the other two, is a vacant lot owned by David and Rebecca Mitchell with a parcel number of 082716 48870 0000390. Barring the difference in the ownership, the facts of the case are the same as the prior two cases. And if the city could just simply stipulate to that, with the violations being from July 13th to July 18th for a period of 5 days as of the other two cases. And if the board is satisfied with that, the city has nothing else to present.
Thank you. Ms. Silva, anything else from you?
Nope.
I think we don't, unless Mr. Trask says we have to, I don't see any need to summarize further.
Well, we need to do a motion.
Yes,
Okay.
I can close the public portion of the case now then, and I'll ask for a motion from the board.
I move that based on the testimony, evidence, facts presented in law, that the David and Rebecca Mitchell were in violation of Section City Code 852 of the Tarpon Springs City Code from July 13th to 18th, and a fine of $25 per day for 5 days, or a fine of $125. In addition, I move that the city be awarded $87 for the costs it occurred in prosecuting the case.
I'll second that as well.
Thank you. Assuming and not hearing any further discussion from the board, I'll have the clerk call the roll, please.
Ms. Tellier,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes,
Vice Chair Archer,
Yes.
Chair Wade.
Yes. Now we'll move There were no affidavits of non-compliance. We'll move to affidavits of compliance. We can use the ones that do not have a dollar amount attached to them, which are items number 8, 7, 8, can be heard together.
We can also do 9. Oh, that's old business. I'm sorry. I'm sorry.
That's where it gets complicated. So we're going to just do.
Yep. Okay.
We'll do 6 on its own. We'll do 7 and 8 together, and then we'll work through the weeds. Could I hear a motion for item number 6, 134 North Spring Boulevard?
Yeah, I move that we approve the affidavit of compliance in case number 20-800000074 and award the city prosecution costs of $156.50.
Can I hear a second?
Second.
Ms. Manousis, we can do a voice vote, I believe.
Yes.
Correct.
All in
All
favor?
in favor?
Yes.
Aye.
Yes. Any opposed? Thank you. Let's do items 7 and 8 together. If I could hear a motion, please.
I move that we accept the affidavits of compliance in case number 18-800000695 and case number 19-800000050.
I hear a second.
Second.
Ms. Manousis, voice vote, please. All in favor?
Aye.
Aye.
Any opposed? Thank you. We always appreciate the residents or citizens that come into compliance. Item number 9,
Okay.
motion to quash. Mr. Trask, I need help.
Okay, this is a motion to quash that has been presented to the Code Enforcement Board by city staff, and we'll let Mr. Gasson go ahead and explain them as they appear. You've got 2 of those before you get to the fine reduction requests, but I'd be
Yes.
happy to answer any questions once he makes his presentation.
Thank you. Appreciate it.
So this first one, 18-800000706, the city's requesting the motion to be quashed because the ownership had changed. So
Yes.
that's the simple aspect of it. Originally, they were cited under one owner. Somewhere in the process, the ownership had changed. So when the board order came out, there was a different owner. So the city's asking for that motion, that board order to be quashed.
And all we need to do is have someone make that motion.
That's correct. It would be a motion to quash the order.
Could I hear that from the board, please?
I'll make a motion to quash the order.
Thank you. Second,
Second.
Ms. Manousis. Let's clarify item number 18-8000706, 224 East, 224 East Tarpon Avenue. And we'll have a vote.
Ms. Tellier?
Yes.
Ms. Archer? Oh, wait a minute. 1 minute.
Item 9.
Yeah, hold on. Got a wrong roll call form here. So we'll go Ms. Tellier,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
No.
Vice Chair Archer. Yes. Chair Wade.
Yes, thank you. We're continuing on motions to quash. Item number 10 is 19-800000699. It's a vacant lot, parcel 13, 27, 15, 67896, 0000110. It's next to 439 Lincoln Avenue. The owner is listed as Craig Fowler. Officer Gasson?
Thank you. As you stated, the city's requesting the order be quashed on this. Basically, what happened is the lien and order of November 14th, 2019, which was signed on November 21st of 2019 and recorded on November 21st. The initial case was initiated on a different parcel owned by the same property owner, which effectively made it a repeat violation. Prior to the code board hearing, it was discovered that the violation was actually on a different parcel. A location transfer within the system was made and the property owner was notified of the transfer. The location transfer resulted in having the same violation occurring at the same time, which basically was doubling it up. When the location transfer was made, it nullified the repeat violation because the violation was still open. So that code case should have been closed when the violation transfer was made and not run the daily fines. The fines for the case had been paid in the amount of $532.50. So one, the city is asking that they recommend that the payment be applied to the initial case, which is 19-8000317, which still has a balance of approximately $2,431. But we're requesting that that order be quashed, those fines be applied to that other case. That's what the city's request is to the board.
Do we need two motions then, one to quash and one to move the money?
Okay, so let me just jump in here. The money issue is not something that you should be involved in. This is something
Okay.
that the city clerk can handle. They can either refund the money or apply it. We'll let them do that. That's not something that I think that you should be involved in. So it'd just be a motion to quash, and that would deal with the order that was entered. But I don't feel comfortable with you basically telling this person that we're going to use their money for some other type of violation. So, but they may want to do that, and it may be what is done. But ultimately, let's let the city clerk treasurer deal with that issue.
I'm all for that. Thank you.
Okay. So we just need a motion to quash.
All right.
Can I ask some questions? Just a couple questions. Can you tell me, Officer Gasson, can you tell me when the transfer occurred? And was it within 30 days of when we had the first repeat
Hearing.
violation?
Well, one thing, I can't give you the exact dates, but the location transfer is a term that we use within our computer system. This had nothing to do with the owner. It was an internal audit, if you will. We discovered the error and then we transferred it to the correct parcel. So it wasn't the owner transferring ownership or anything like that. It was strictly us in code enforcement discovering we had put the case in with the wrong parcel number. We moved it or did a location transfer within our software to the correct address. So we created the duplicate. So we're trying to correct the record from our error.
Okay. And is Craig Fowler the owner of the other 19-8000317?
Yes, he is.
Interesting. Okay, thank you.
Any other questions? Now, if we could hear a motion.
I move to call 19-800000699.
Thank you. Do I hear second?
Second.
Thank you. Let's do an actual roll call vote. Ms. Manousis, please.
Ms. Tellier,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Vice Chair Archer, Chair Wade.
Yes, thank you. Now we'll move into our fine reduction requests. We have two to deal with today. The first one is for 514 Lime Street. Pierre Fowler and Tiffany Coleman.
And we do have someone present on that case.
Yes, sir. We do have a raised hand if you'd like me to allow them in.
Oh, yes, please allow them in, and we'll need to swear them in.
Good afternoon. This is Graydon.
Good afternoon. Could you identify yourself, please?
Yes, my name is Graydon Doe. I'm the attorney for Mr. Fowler. I also have a witness, Otilia Andino, who would quite possibly testify if we have to put our case on.
Could I have the smell? Could I have the spelling for her name?
Otilla Andino.
Okay, Madam Chair, I want to make sure that the board understands that you have a specific rule that talks about
Uh-oh, you froze.
finding do not take evidence. Under Rule 5, Section 4 of your Code Enforcement Board Rules of Procedure, it says you're to make your decision based solely upon the written petition.
That'll be fine.
Has the board had the opportunity to read the petition?
Yes.
Could we confirm that everyone has had that opportunity?
Yes.
Yes?
Yes.
Ready?
Yes.
Thumbs up. Thank you for. Ms. Archer, did you say yes or do a thumbs up? Thank you. Is there any discussion from the board? I found there was a great gap between the end of October or the end of 2018 and one of 2020. They didn't indicate any monitoring being done on the property during that time period. Just a note. All right. Could I have unless someone else has something they want to say? Do we entertain a motion? There's a form motion for this.
I entertain a motion to not recommend the reduction of the fine for
Thank
this
you.
case.
Thank you. Do I hear second?
Second.
Ms. Manousis, could you call the roll, please?
Ms. Collier,
Yes.
Ms. Norfleet,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Vice Chair Archer, Chair Wade.
Yes. Mr. Trask, do you summarize for them or not?
I'd be happy to. So, Mr. Doe, the Code Enforcement Board has denied the petition for fine reduction. There'll be an order entered within about the next 10 days. Will be provided to your client and you at the address listed at the property appraiser's records. If you have any questions after the meeting, you can go ahead and call me as the city attorney, or you can contact Code Enforcement. We'll be happy to answer any questions.
Thank you, Mr. Trask.
Final case for today,
I'll call Trask.
item number 12.
I'll Trask for you.
I'm sorry. There's a final number 12, petition for rehearing or reconsideration. Item number 19-8000176, 1404 Meyer Lane. Jean Ulloa.
And Madam Chair, I want to let you know that we do have an attorney present. He has an attendee and he's raising his hand. But once he's acknowledged, I'd like to go ahead and read the rule of procedure, and then we can move forward from there. So, Mr. Pfizer, can you hear us, sir?
I can.
Okay. So you here on behalf of the property owner?
Correct, Mr. Trask.
Okay. All right, so Madam Chair, if I can, I'm going to go ahead and read the rule of procedure because this doesn't happen very often. This is not a fine reduction hearing. This is a petition for rehearing. So I'm reading from Rule 5, Section 3. Any aggrieved party may petition the board to reconsider or rehear any board order resulting from public hearing. This petition must be made in writing and filed with the board secretary no later than 30 days after the execution of the order and prior to the filing of any appeal. Upon receipt of the petition, the board will consider whether or not to reconsider or rehear the case. A motion to approve a petition to reconsider or rehear must be made by a board member who previously voted on the prevailing side. A motion to approve a petition to reconsider or rehear a case must set the date and time for the rehearing. The rehearing may be held at the time of consideration of the petition if the petitioner and all other parties agree. The board will not hear oral argument or evidence in determining whether to grant the petition or reconsider or rehear. So that was the reading of your rule of procedure. So I would direct you to the petition that the attorney prepared and has presented to you, and you're to make your determination based solely upon that pursuant to your rule of procedure.
And that, his filing was made on June 17th. Or is that from the board hearing was the 17th? And his filing was the last page. July 17th or 16th, so that was within 30 days.
30 days.
One of my questions, Mr. Trask, was the June 17th was not the hearing. The hearing was a year ago, wasn't it? At that August 8th of 2019 hearing, I thought that the June meeting was not a complete rehearing.
So the Code Enforcement Board evidently held a meeting on June 11th, 2020. And it was for a affidavit of compliance, non-compliance hearing. And that's what this is being addressed to, is the non-compliance hearing that the attorney appeared at. You remember that I was on vacation that meeting and another attorney from my office handled it. So I don't have all of the details, but I'm taking his petition, paragraph 15 specifically says that he appeared on June 11th, 2020 before the board. So I assume that this is all this petition is being directed to is the compliance, non-compliance hearing that was held on June 11th of this year. So it is timely.
Okay. I went back and watched the August one and this one, which are, as we know, archived on our YouTube section. So I wanted to make sure that the timing was correct. And there were a couple of objections which he cited, which I disagreed with, having rewatched that, but perhaps that's not even relevant. It's just take it all or nothing, correct?
It is relevant, your memory of the meeting. And if you needed to look it over again through the video, obviously, then that was acceptable. You should take the petition that he's filed as being the argument that he's making and give it whatever weight that you think is necessary based upon his perception and his argument as a lawyer on behalf of his client, and make a determination as to what you think is appropriate based upon that petition. If you were to rehear it, you're not going to rehear the entire case. You're only going to rehear that one hearing, the compliance, non-compliance hearing. You're not going to go back to the original order finding the violation. You won't be doing that. This is a rehearing of the compliance, non-compliance hearing.
Okay. And it's your legal opinion is that he had met the qualifications for requesting a rehearing.
It is a very good petition for rehearing and reconsideration that the lawyer has prepared. It's He is moving forward under your rule of procedure, Rule 5,
Okay.
Section 3.
Okay.
Mhm.
So request for rehearing. So someone on the board either needs to make a motion to rehear or not to rehear, correct?
That's correct. And if there is a motion to rehear that passes, then we'll go to the next step, and that is do we hear it today? Or do we hear it, maybe, for example, next month? So it'd be a two-step process. If a petition for rehearing is denied, then we're done.
And do we need to cite reasons for it to be denied?
No.
Okay, thank you. I'm sorry to ask so many questions, but we just don't have this one very much.
I understand.
And we want to do it right.
Correct.
Does the board wish to make a motion?
I'll make a motion in the petition case for rehearing reconsideration number 19-800000176, 1404 Meyer Lane, Gene Uola, I guess, that we deny this petition for rehearing at this time.
Second.
Ms. Manousos, would you call for a vote, please?
Ms. Tellier?
Yes.
Miss, oh, okay. One second.
I understand.
Ms. Tellier?
Yes.
Ms. Norfleet? Did we miss Ms. Norfleet? Is she offline?
Looks like she's dropped
Yes.
off.
Okay.
Yeah.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Vice Chair Archer?
She said no.
No, okay. And Vice Chair, or Chair Wade?
I wish to deny, correct.
Okay.
What was the result of the vote, Michelle?
That was
Is that
5-1.
You had, didn't you?
One,
Maybe 5-2.
5-2.
5-2.
Well, Ms. Norfleet is not here,
She's not here, so she didn't vote.
so that's correct.
5-1.
Okay.
I
So,
counted five.
Oh, three
I didn't
to
hear
2.
another no
Yeah.
vote. Yeah. Was there another no vote?
Yes. Mr. Creamer, didn't he vote no?
I did.
And Becky voted no.
Mr. Kramer, you voted no?
No. Well, I voted yes.
Oh, we
Okay.
There you
did.
go.
Okay.
Okay.
Oh,
Okay. All right, so just to make sure that we've got the vote, Ms. Norfleet was not in attendance. We had five in favor of the denial and 1 opposed to the denial. So the petition for a rehearing has been denied. So, Mr. Pfizer, there will be an order that will be entered and sent to your client and you in response to the petition for rehearing. It'll be done within the next 10 days. And if you have any questions, you can call me after the hearing.
Thank you, Mr. Trask. And are you in receipt of the order on the motion to preserve evidence?
Yes.
Okay, thank you.
Thank you. Okay, so we can go on to the next thing, Madam Chair, approval of the minutes.
Alrighty, we have minutes from June and July in your packet. You were given a chance to review those. Does anyone have any corrections or additions to make to the minutes? Not hearing any, I'll ask for a motion to approve the minutes for June and for July.
I'm making a motion to approve the minutes for June and July.
Thank you. Second?
second.
Thank you. We can do this by voice vote. Ms. Manousos?
All in
All
favor?
in. Aye.
All opposed? Motion carried.
If anybody has any public comments, I'd like to pass along my condolences to you, Ms. Manousis,
Thank
and
you.
your family. And we want to thank Ms. Vacacy for her service. She's had some reasons that she's needed to resign from the board. Will we be having a new member? I think they appointed one.
Yes, they did appoint a new member Tuesday night. His name is William Stamus. He was on the line earlier just to get a feel of how the board works, but he will be at your next meeting.
Thank you. I made note of that at the meeting the other night, and we'll look forward to having him with us.
Julie,
Yes?
this is Sunny. My battery pooped out and I'm back in, so I didn't know whether I'd get to put my vote in on the motion for rehearing that I seconded. I'd like to put in a yes, but I don't know if that's possible after the fact.
Okay.
Now, that hearing's been closed,
Okay.
so we're not going to open it back up again, but I appreciate you letting us know.
Yeah, I didn't
Thank
know
you.
there was a problem with my seconding it and then not putting in a vote, so.
We appreciate that. Thank you. Anyone else from the staff need me have a comment or wish to speak?
City has nothing. Thank you very much.
It's a pleasure to
Seeing
see
others-
Officer Gasson's smiling face.
And I wanted to thank the whole code board office for chugging right through. Nobody can use an COVID excuse for them. You guys have done a great job continuing your good work. Seeing there's no other board business,
Yeah, Julie, thank you for that, Julie. It's stuff for the police department too. It's stuff for everybody.
that's right.
Appreciate your comments.
Thank you, guys. Meeting's adjourned.
Thank you.